I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we're diving deep into one of the most misunderstood and, frankly, one of the most critical components of digital privacy: consent. Consent is a term that's widely thrown around, but often lacks definition. In a world where every click, swipe, and scroll can trigger a data transaction, what does it really mean to give consent online? And frankly, is consent even possible? If it's possible, how can organizations ensure that consent is meaningful, informed, and respectful of user choice and autonomy? To discuss these issues, I've invited Max Anderson, a co-founder and head of product at Ketch. Ketch is a leading provider of consent and preference management technology and solutions, and have long been engineering solutions to privacy challenges. In addition to being on the front lines of operationalizing privacy requirements through technology, as you'll hear, Max is a proponent of thinking about consent online differently, and maybe in a manner that is both more clear and gives companies a better access to data so that they can innovate. Max, welcome to the podcast.
Thank you for having me, Scott. It's good to be here.
So, I really want to dive into consent because it's one of those areas that, especially on the internet, is not well understood. People haven't understood what is required, why it's required, what purpose consent plays, and how is it that we are able to obtain consent. So lots of really good and interesting issues, including whether consent is something that is meaningful any longer, especially as an average web user goes and moves between different websites. But let's just kind of start with the basics. How, from your experience, how do customers, clients see the role of technology in obtaining consent? And what are the basic solutions that are out there for obtaining consent?
Yeah, first and foremost, couldn't agree more. This is probably the most misunderstood topic in the privacy remit, at least according to me. And also perhaps the most, well, I would say a lot of people who think they understand consent may not, at least to the level that we experience day to day over here at Ketch. So it's a fun topic, and it also happens to be one of the most enforced issues in privacy. So there's a lot to get into here, but at the fundamental level, the role of technology in facilitating consent is usually done through a consent management platform. The average human can experience those through, the awful implementation on the internet today through cookie banners that we all kind of go to a website and ignore before you go and browse whatever the digital content you're browsing is. The theory of a consent management platform is that it's a technical mechanism that facilitates some sort of a contract for data use terms between an end user and a business. And all of the things that happen with the data to those ends as described in the kind of cookie banner. And we can come back to the aperture of consent, right? Is it cookie or is it broader than that? Certainly have a point of view, but at the fundamental level, a CMP is supposed to facilitate that dynamic of yesness or no-ness to some particular data use between an individual visiting a website and somebody who's, the owner of the business behind the data.
Yeah, and I love that analogy of being that this is like a contract between the user of a website and the publisher of a website. In some ways that perfectly encapsulates what the legal theory is, and in some ways is completely off in terms of actually how that relationship works. But, if I'm thinking about that correctly, it says, Scott, who goes to a particular website, and I am then going to see that site is going to give me a lot of legal information for which I am looking to avoid as much as possible. First, I may get that banner that comes up in place and it says, do you accept cookies? Do you reject cookies? Do you agree to essential cookies or performance cookies or, marketing cookies, any number of different choices that I may get, for which then presumably if I say reject all or accept all, that's part of my essentially agreement as I use that website. And then I layer on top of that the terms of use, the terms and conditions that may be embedded in the footer of the website. And then I layer on top of that the privacy notice or the privacy policy that may be provided. That may not be formally a contract, more be disclosure. And then as we increasingly see, there are a number of other levels of different notices, different types of disclosure. And then we have the idea of, well, what types of consent we're obtaining for direct marketing versus cookie marketing. So lots of things, lots of frankly choices as people try to go to a news website, spend 20 seconds trying to read the headlines, but are yet provided with at least 30 minutes of reading as to whether they are able to use that website. I mean, interested in your perspective. Obviously, that's more of a dramatic view into web experience, but probably not that far off.
No, I think it's pretty fair to say that if somebody wanted to actually evaluate all of the supporting documents and content that at least discuss the data use terms, there's quite a bit of reading. And I don't think, I mean, certainly nobody does that unless you're a privacy pro, you're reading privacy policies or you're writing. But certainly there's more to understand about the data contract than perhaps there is appetite to engage in the same amount of time on in the digital platform itself. No refute there.
Okay, so with that context, let's try to think about what is the role of that consent and preference management system, the CMP, as some folks like to refer to it. I think one of the tools, as you were mentioning, is to accept cookies, to reject cookies, to leverage those tools for do not sell opt-outs, those kind of things. From your perspective, as you're helping clients implement this technology, how are you approaching this type of conversation? Because, one of the things that I think we've all discovered as this area has been litigated over the course of the past 5+ years is that there is oftentimes a lack of understanding of what type of data is being collected on a website, who is collecting that data, and how that data is being used, which are fundamental questions for you to be able to understand in order for you to disclose to users the appropriate information, and then also to effectuate any choice that those users may have with respect to their data.
Yeah, I mean, I think that's a huge topic. And I think in there's probably two subtopics at least. One is, the unfortunate fact that most companies have no idea what it is they're doing with data. You kind of see the data mapping category show up to at least purport to solve that problem. And we can talk about that. And then the other subcategory is what's the right way to think about the best way to implement all the disclosures and the choices and what needs to happen. I think maybe the first thing that we try to advise customers or people who are getting into the consent management remit to embrace is that I feel strongly that consent management is not cookie consent. And I think that we talk about cookie banners and we talk about cookie consent, and most companies implement in their parlance and in their paradigm a cookie consent process with this very narrow aperture that the role of cookie consent management platforms is supposed to facilitate the correct or the lawful setting of cookies on a device. And I think a lot of that just stems from e-privacy. I think that was the first law that really took on some contract rules, terms, conditions around how a company could set a digital tracker or a cookie on a device. But I think if you fast forward, even through to GDPR, the idea of purpose limitation seems a bit broader. It's not about setting cookies as much as it is about the use of data and the lawful use of data. And that key change has dramatic technical implications that I still don't think most people are appreciating, right? And then fast forward to, maybe the next big monumental moment in the history of at least what I've been seeing or since I've been in this space, do not sell. And in the context of consent management, the idea of selling data, that term with whatever meaning, depending on where you are, has implications that are not narrowly focused on, can I set a cookie or not? So the first thing we try to get people to understand is that if you want to be set up for a durable privacy implementation, you need to embrace the fact that your consent management problem is not limited to the device and the setting of cookies. First and foremost, does that make sense to you? I don't know if that's a wild idea for you and how you practice, but that's definitely the first thing that we usually get into it with customers around.
I mean, 100%. I mean, if I were to extend, that issue in ways that I think it often comes up with clients is that consent and preference management systems are linked and have to be a component of a larger data governance process within an organization. In other words, there's still this misimpression, and I see it almost daily from organizations who say, well, because I have possession, physical possession to the extent you can have physical possession of data, resides on a hard drive or on a cloud system that I own or that I license. Thus, I have the rights to be able to use that. And the answer is maybe you have rights, but probably almost in all cases, it's qualified versions of those rights. And those rights will differ by databases, could be differ by relationship, could even differ by data element, especially when you are implementing a consent and preference management tool, which gives you the right to be able to use data elements one, two, and three for purposes A, B, C, but data elements four, five, and six for X, Y, Z. In which case, you getting all of these rules, which makes sense if it was that contract and Max and Scott were ironing out the terms under which Max can visit Scott's website, and we were like, okay, have an idea, this is how we're going to do that. That makes sense conceptually on a one-to-one relationship. In practice, websites are designed in volume, and so scaling that is near impossible. And that to me is where that consent and preference management tool has to be really part of that larger governance operation.
I think you're 100% right. What you just described is funny, the idea that you can use data categories A, B, and C for purposes one and two, but not three for this individual. That set of dimensions is I think the spirit of what a lot of these, laws target. But I think technically, even for a company that's well-intentioned and has the resources to go and implement it, still pretty far out of reach. I mean, you talk to a lot of security practitioners and database administrators, the idea that you can control access when somebody writes a query or a machine writes a query to a database to filter on the column and the row level, which is basically what we're saying. Row 10 for Scott, column 1 is, let's say, sensitive data, for example. Oh, I can't use column 1, even though the query wants to access column 1 for Scott, but maybe for, Dan or someone else, you could. That's pretty far out of reach. I've never really seen a company implement that effectively. The basics, right? If you just remove how do I take Scott's data, make sure I only use Scott's data for the right purposes that, he's allowed me to use it for, even that level of filtering, once you leave the device, the website, for example, is pretty infrequently implemented. We spend a lot of time on that problem domain. And again, the number one obstruction for the average privacy practitioner is a pretty narrow view that consent management is just about setting cookies. And if you block cookies that shouldn't be set, you've solved the entire problem. And so one of the things that I like to at least raise with customers is this idea that, let's imagine in the context of US privacy, do not sell, where the interpretation of sell might implicate advertising. And let's just, lots of people, lots of different opinions. I don't want to show up here and tell people what the law is, but there's certainly a school out there that believes strongly that a sale is cross-contextual behavioral advertising. And let's imagine a company's use of Facebook ads on their website is in scope. So if I show up to a mobile app or a website, let's say it's Nike or whatever, and Nike's flowing my data into Facebook to send me, targeted ads when I go use Facebook. It's a pretty common data use case for basically any brand. And I then opt out of the sale of personal information. What should happen? In theory, all the data that is already in Facebook, because remember, I've been using the Nike digital ecosystem for a month before I've opted out. So there's a month's worth of my interactions that are inside of Facebook. Nothing about controlling the setting of a Facebook cookie on my website is going to change the fact that that data that's already in Facebook is being processed and built into segments and lists and part of the advertising kind of paraphernalia for that brand. And so if you really want to opt someone out of sale, you've got an obligation that goes far beyond the browser and far beyond, setting cookies. So that's an example I like to give to customers, is they kind of on board of, oh, wow, okay, the circle is much bigger than, what we traditionally thought.
So I 100% agree with you that it's much bigger than what it is that people initially perceive this as. But there is a lot to unpack even in the data relationship that you described. And you're talking about, one instance of one publisher with one tracking technology. And in reality, there are many other participants in the ad tech ecosystem, from the publishers of the website to the platforms that are operating on those websites to the real-time bidding agencies, and then the advertisers on those agencies, and the technology that supports all of those things, right? So a very complicated ecosystem. But yet the law says that I need to have a single button that says do not sell, or in California, do not share my information. So I basically have I have to take all of that complexity that sits behind all of these various relationships, and I need to dial that into one particular choice for a DNS, or for a do not sell or do not share. Similarly, I have the same issue with the cookie opt-ins, opt-outs, right? I have to take in all of these tracking technologies I have on my site. I have to then take those and categorize them based on whether I think they're essential, whether I think that they're analytics, whether I think that they're marketing. And then I need to dial that into a very simple choice that individuals have, say yes or no. So I guess, how are you approaching that, bringing that complexity into a way of then making it almost very simple for a user to make decisions that have a large scale impacts on the back end?
Yeah, I mean, you certainly get quickly into UX with a question like that, user experience for a lot of these notices. I mean, I'm squarely of the camp that nobody does this well. There are a few brands that do it well, but the idea that the tension I normally see is that there's a lot of zeal and appetite to be very prescriptive and understandably lawyerly in some of the language that you use describing the data use conditions and terms in the context of a switch that says advertising, for example, in one of these consent mechanisms, that might be a little bit hard for the layperson to fully understand. But it can be done. But that's the first thing, is you kind of got to resist the urge to make this contractual sounding, even though it is. If you're optimizing for the end user, and the way that you present these options, I would argue a cookie banner that we experience today is the worst possible implementation. If you think about anything you do with digital products, there's really nothing that is, perhaps maybe in a health context, would be analogous, where you show up to the digital realm and you're basically bombarded with 38 pages of T's and C's before you can do anything in the digital experience. Like, it's just not how people who've mastered the digital world operate, because it doesn't work. If it worked that way, people wouldn't have created the iPhone. It would have been a totally different world. But the idea that digital experiences should be contextual, they should be simple, ask the relevant thing, don't ask too many things, people get fatigued, all of these ideas that are pretty prominent in digital marketing or just building digital applications haven't really shown up in the context of privacy. And so, to your question, like, how do you simplify, or how do you make it really easy? The abstracting of all the stuff that happens with data on the back end doesn't go away, right? Technology vendors like myself and many others in this community, we live and breathe to abstract that gore and make it easy for companies to implement. But on the user experience side, there's still an obligation, or at least a conversation that we could have about, are we doing this the right way? Are we presenting the right options in a meaningful and intuitive way? And my emphatic position as of today is no. People are addicted to cookie banners and surfacing T's and C's and opaque, ambiguous language that, by the way, nobody interacts with. The scale here is, I think there's some research study done a year and a half ago that basically looked at the accept all, reject all, X button, ignore, and all these interactions you can have with a standard cookie banner. And basically, I think 60% of the interactions are the go away actions, click the X button, do nothing, etc. Only 5% reject, and then 25% accept. right? So the 70% is basically just get it out of my way. If that doesn't tell you that we're surfacing it the wrong way, I don't know what other metric could, emphatically make that point.
I couldn't agree more. And, I think it is a real challenge for organizations to try to envision another way of doing this. In some ways, there is a safety in being in part of the pack, and a danger to be innovative in this space. Like, it's the reason why, if you were to read SEC filings, you will start seeing that they look very similar, right? To, why do you have a clothing company who sounds like they're, a streaming company? And it's because, they're all in the position of making sure they're staying within that pack, as part of their disclosure. I mean, privacy works the same way. If you think of privacy as being a legal obligation, a compliance concern, as opposed to something that is going to create some or additional kind of user experience or value, then you're trying to say, well, what is the least that I need to do in order for me to be able to operate my website? And how can I do those things that's going to give me maximum amount of the data to be able to use for all of these other secondary purposes? In which case, you get to where we are right now, right? I have to put up a website banner. There's, obviously the law here is catching up. Well, you have to have a reject all button? Can it just have accept button? What happens if you just hit X? Does that constitute agreement? Does that constitute a rejection? All of those things are happening around us. But in reality, that is 5, 7, 8 years behind the time of when those practices started to come into place. So from your perspective, Max, I certainly disagree with anything that I'm saying, but I'm interested in, what does a reimagined view of this look like? Is it more just in time kind of consents and notices? And doesn't that constitute really not a really successful or engaging user experience if they're constantly being prompted? Do you want to share the fact that I looked at this video? Do you want to share the fact that I, clicked on this particular ad, versus something that is maybe more universal in nature, where you're making these selections one time as opposed to 50 different times by looking at 50 different websites?
Yeah, I mean, a lot to unpack there. I'll start by coming back to one of the things you said about, data use. I think there's certainly a school of thought in the privacy arena that, you just got to be compliant, right? And if this were just about compliance, who cares? There wouldn't be an economy surrounding this space. But it's not just about compliance. It's about the number one thing that drives business today, and that's data. And so there is immense pressure to maximize a company's data footprint and wield it effectively. And if you were to just look at software, look at technology, for the last 15 years, the race has been, how do you process data effectively? How do you process more of it? How do you use it to drive business outcomes? I remember the last company that I worked at before starting Ketch, we were AWS's third largest customer. And and this was like, 2006, earlier days for AWS. Just to contextualize, like, we haven't been very masterful at wielding and operationalizing large amounts of data for business outcomes for very long. The AI boom, the kind of large language models that we're seeing now, that's a whole different, dimension of mastery. But the point is, that's the target. And everything that we're doing here is kind of the constraints around that particular target for a business. And so the reason I bring that up is this whole cookie banner implementation pattern, it is impossibly detrimental to those ends of wielding data for business outcomes, right? If we look at the basically 25% acceptance rate in Europe or in opt-in regimes, you've got a 75% data loss problem. And the thing that astonishes me is that business practitioners aren't more involved and don't fully understand that that's, the data faucet gets turned off when you implement a cookie banner that way. So I do think that there's an opportunity to not just be compliant, but also to do this in a way where you actually maximize your data footprint. And that's a conversation we try to have with customers. And that's one of the arguments for a new way of doing this. And that, simply put, is contextually lacing the question of data use permissions into the digital experience, right? If you search for something, right, that might be a relevant time to ask an individual for the ability to save their searches to, make their searches more effective. And the checkout, right? Oh, you want targeted offers? I'll save your shopping cart and give you targeted offers next time you use the digital application if you allow me to do so. And we see these things, by the way, in every other facet of our digital experiences, right? Oh, I'm going to buy something for dinner. It's like, hey, do you need utensils? It's all about the contextual delivery of a question around data use where you can clearly highlight the value exchange. There's a good reason for businesses to want to save and store some of this information that does, in fact, benefit the end consumer. And they're just not asking it at the right time, which results in, I think, a smaller data footprint. So the idea or the target here is do it the way every other digital experience does it. Ask for the permission at a moment where it's relevant. Your phones do that all the time, right? You don't open your phone and get all the questions up front. You open Maps and it says, hey, would you want precise geo, any geo? Your choice, but it's relevant because you're in a map application. And somehow privacy's just completely missed the mark through, a cookie banner implementation that I think diminishes data footprint for companies.
So from your perspective, right, there is a clear value proposition to the business to get this right. I mean, it's almost like you were describing the example where you have, that the value is really in the data. And I would guess, as I'm hearing the way that you were describing that, maybe I would amend that slightly, is that it's the value is in the process, the data that you can process versus kind of the raw data, right? If it's almost like I am, this is not my area, but presumably there's not a lot of value in oil that you get from the ground. The real value that you get out of that is being able to use that data and refine it in a specific way for specific purposes. And so having the big barrel of oil that it's not useful is just going to result in costs to store that and environmental concerns versus the data and oil that you're able to refine or process and then be able to use to accomplish a business purpose. So if I'm extending kind of that analogy, which I apologize if it was kind of somewhat tortured, but bear with me. It's like if I'm thinking about this right, lots of data coming in through these websites, and that data, it doesn't all have the same value. But by implementing so all of that raw data is going to be restricted. And as the days go by, more and more restrictions will apply to it because of the laws and the regulations that are being imposed on it. But the consent and preference management solutions and strategy can perhaps make more of that data be from its raw form to be then data that can be refined or processed to accomplish those business objectives if you do that consent and preference management right.
Yeah, it's ironic. I grew up in the oil and gas business, so it's a funny analogy to have selected. But yes, I think broadly speaking, you're in the area that illustrates the point that the consent and preference done correctly is the means by which you ultimately derive value from the data, and I think that's the key point here.
So if I'm thinking about this, Max, there's two other things I want to make sure we have a chance to talk about. And that is, when is consent needed? I mean, what is that consent going to be required? And that's obviously the biggest thing that we have spent the past 3-4 years debating, especially with regulators and, as a community, as, what constitutes, quote, sensitive data for purposes of you're using that data for advertising or disclosing that data to third parties, and what constitutes sensitive data at this point may be anybody's guess, because it tends to be law or regulation specific. It is depending on the geography and jurisdiction where that data was being collected. It depends on which regulatory authority is interpreting those rules. And at least in my experience, It's sometimes the individual within those regulators who is making those determinations, and that's not even bringing in the thousands of plaintiff lawyers out there who also have a view as to what constitutes sensitive data. And at the same time, in many places, the push is to say you need to get consent to be able to use that data for either marketing purposes or for the disclosure of that information to any third parties, including for marketing purposes. And that requirement has been all sorts of created issues under with the FTC here in the United States, under HIPAA with OCR, and all of these many lawsuits that we have seen, including for things like the VPPA. Interested in your perspective on that issue through the lens that you see this world, of how organizations can approach the question of within my website, what data is sensitive and what is not. And then importantly, how is it that I create an effective consent and preference management tool against those different types of data?
Huge topic. Maybe two categories is, what is sensitive and how do you know whether or not you're collecting sensitive or you have exposure? The second is, what do consent mechanisms need to look like to account for all the nuance that we see in, the last 2 years of enforcement or just general happenings in the ecosystem. What is sensitive is, it's somewhat regulatorily dependent, right? Regulations have different definitions, but certainly there are broad strokes of what is sensitive, and all the people who are listening who are actually practitioners and on the law side of this industry are better equipped than I to define it. But we can talk a little bit about things that denote health conditions. I think one of the things that if you're a digital property owner, you don't always appreciate in this context is whether or not the information itself is sensitive, or could it be derived to create sensitive data? So an example I like to use a lot is, let's imagine you're an e-commerce site, or you're a commerce site of some sort, and you have products that in and of themselves innocuous, right? So pretty traditional play. I own this site, or I own this digital experience, and I want to figure out whether or not people are shopping or looking at various things. And in order to do that, I'm going to send a bunch of data to my analytics tool like Adobe or Google Analytics or what have you. And I'm going to, by just general way these tools work, there's just pretty standard, default implementation for these tools is I'm going to collect the URL. And I'm going to take the URL and I'm going to kind of chunk it or parse it into its constituent parts. And, there might be, commercesite.com/products/product code. And product code in and of itself is, okay, great, sure, product code, sneakers, bikes, toys, whatever. But in certain commerce considerations like prenatal vitamins, the fact that I can take that individual's ID, I can match the fact that prenatal vitamins were the product looked at, I can infer the pregnancy status of that individual, and now you've got a sensitive data leak to some third party. Which we see a lot of, that's like the gold mine for plaintiffs' attorneys right now, and CIPA suits, at least as we've seen it. So what is sensitive is both a definition around, what constitutes sensitive as defined by regulation, but it is also the derivative works possibility of sensitivity from the actual data that shows up, or it gets shipped from the device, whether it's a mobile phone or a website. And I don't think a lot of companies have a grip on that. And I think it's a hard problem to solve, right? You've got privacy pros who traditionally own this problem. You got marketing teams, digital teams, data teams that are off, collecting and harvesting data. And that line of communication is relatively broken. Not because people are nefarious inherently, but it's just not a traditional communication path that exists within an organization. And so the person holding the privacy bag has actually no idea what data is going where. So certainly as it relates to data sensitivity, there are controls that need to exist, but then there's an exposure question that people can't answer. So there are good tools and technologies out there for companies to avail themselves of, to at least understand and diagnose what data you're collecting and where it's being sent. Network traffic analysis is pretty good at that. I'm not a huge proponent of code scanning, even though it's pretty hot right now. I think it's misunderstood and it has its role, but it's not an end all be all. And that's, thing one, understand what data you have, at least what data is leaving the device, because that's really where enforcement focuses. We could spend 9 hours talking about the creative ways in which I can tell you what data you have in your SharePoint server, and that's cute, but it's not what drives regulation. So we try to kind of keep customers focused on where do you have exposure, and you have exposure on your website because plaintiffs' attorneys and enforcement agencies can see that, and it's just the low hanging fruit today. So that's kind of the what's there and is it sensitive, and then there's the what do you do about it or when do you need consent, kind of the second part of your question. Again, not to skirt it, but like I'm probably the least equipped to tell people when they need consent. That's really it's very regulatorily driven. I don't like to play a lawyer on TV, but we obviously there are laws that necessitate consent, opt-in consent, opt-out mechanisms, California, GDPR, et cetera. I think as a technology provider, some of the trends that we've seen and one of the decisions we've made about what to do about consent is that it needs to be contextual, not because it's a better user experience, but because the actual requirements that we're seeing emerge from the average practitioner are changing. A few examples of that. Getting, VPPA consent, right? I want to ship, video data. Let's say I've got a streaming service and I use Adobe Analytics, right? Similar analogy to the e-commerce site, but now I'm shipping video data. You watch this show. That has considerations. You might need consent. People that are practicing today are not asking CMPs like myself to put that in the initial disclosure when you show up to the website. They want to embed it into the context in which that event or moment is happening. Hey, you're playing this video. Can we ship off the data for analytical purposes? Yes or no? That's one pretty standard example that we're seeing a lot for video concerns. In the context of CIPA, we're certainly seeing people want to show disclosures, even though California and many US states are an opt-out regime, right? You don't really have to tell them anything and you just have to give them the opt-out mechanism. And that was pretty good until a lot of these demand letters started showing up at people's offices. And the parade to that, at least the parade du jour, is put a disclosure on the website, even though it's in California. That's not a traditional cookie banner. It's a little bit lighter weight. Again, it's contextual. So the emphatic theme or takeaway for us as technology providers was this isn't a cookie banner thing as much as it is a CMS thing, content management system. How do you build a framework and a tool that evaluates rules and criteria about the context of the moment? What website are you on? Is there sensitive data on this website? Is there a video on this particular page? Where is that individual showing up from? What are the legal obligations? And based on all of these factors, considerations, criteria, serve a very specific message. That's not just the full T's and C's in a pop-up in kind of a crude way, but even the law and when do you need consent has gotten so complex that you can't treat it like a single delivery policy. You have to have a much more surgical and tactical delivery mechanism that accounts for all these conditions. And that's been one of the things that, at least the observations that we've made about the way things have changed. I know that's a verbose answer. I'll pause and let you respond.
I mean, it's a lot of information, but on a really difficult topic, because I think, you're exactly right. Like your point earlier around, what does it mean for it to have effective consent and, what does the future of this space looks like? In my view, the idea of what's constitutes sensitive information is driving, where that's going to eventually lead. Because if you find you take a website for a doctor and you're almost looking at it a page by page basis of saying, well, is this data sensitive or is it not? And if it's sensitive, do I need to obtain a consent from this individual to disclose it? Where the homepage to, Dr. Smith says, okay, this is not sensitive, but if I click on the button that says make an appointment with Dr. Smith, then that is sensitive. And then I click on another button that says I want to learn about diabetes. Well, that would be sensitive. But if I want to learn about health conditions that are happening in my geographic region, that's not sensitive. I am like, what am I doing here? I'm going page after page, which maybe I can describe when I have 5 web pages, but most likely for these ones who are doing it at scale are talking about thousands or tens of thousand pages on a particular domain.
I mean, that is why technology exists, right? That's one of the big trends that we've seen. This idea that one, companies, specifically companies that have or use, process, whatever, sensitive data, they don't want to ask that question right out the gate, right? They don't want to say, hey, can I collect your sensitive information on the homepage or on the entryway, right? It's a little bit of a scary thing to ask. And so there's been reluctance to ask that right out the gate. But so they want it contextually, based on what particular content or the experience. Oh, you're going to use this particular quiz to diagnose your issues. Great. Before you use the quiz, sensitive data processing, is that okay? It's a precondition to actually using that little quiz, real use case, real customer. So certainly we're seeing that drive the need for some conditionality outside of user experience optimization. And to your point, there are tens of thousands of pages or parts of the app. And so how do you do it effectively and consistently? That you do that through rigorous scanning of the website, right? People who work in privacy are overly obsessed in an antiquated paradigm called cookie scanning, and it is adorable. And I am cheekily diminishing it because I don't think it's the higher order bit anymore. But your scanning topic can be broadened to look at the content of the page, whether or not there's sensitive data, the content that gets shipped out of that particular browser or device, and its nature in terms of sensitivity, and use those insights or findings to be dynamic conditions that decide whether or not you need to ask for different types of consent. So there are a lot of cool things technology can do in that space as customers show up with strong desire to make this conditional in sensitive data, at least.
And maybe that's my final question here, Max, because I think you're bringing up in your last two responses kind of an issue that I wanted to get your thoughts on, is that there is a great opportunity for technology. And I think you made the point earlier is that, in general, many people don't understand the technology that they're using, which is clear, right? Like I, have a phone in my pocket. If someone were to ask me to spend, 45 seconds describing how that phone worked, I could probably give you 10 seconds. And even that would probably be wrong. Right. So if I'm thinking about the different technologies that's being implemented to address these, there is an inherent tension by saying, okay, this is what I'm going to rely on to be able to meet these particular obligations. But if I don't have a good idea of how that technology works, how am I supposed to be able to make sure that I'm evaluating whether it's being effective to accomplish my objective? Real world example of that is that I've had clients who have been alleged to by plaintiff lawyers to say, hey, your consent and preference management tool is just not working. I'm hitting reject 1,000 different times and still the cookie fires, right? And so it doesn't. You may as well have no consent banner in place, and that can result in all sorts of problems from a deceptive trade practice, all of those things. So, from your point of view, as the provider of really important technology that's really creating important solutions to really difficult problems, how can the users best understand how to use that technology responsibly, given that they are the ones who are responsible for achieving the objective around effective consent and preference management?
It's a good question, and we see it all the time, I think. Look, the first thing is trust but verify. I think anybody who builds software in this category conceivably aspires to do the right thing. I certainly think there are certain technologies that are narrow in their aperture. They are cookie consent products, and I don't think that meets the letter of the law or the needs for today. But that aside, it is easy to misconfigure these tools is the simple point. And that's usually what you get caught on. You get caught because well-intentioned folks with either superior, mediocre, or generally effective whatever technology have misconfigurations that are caught by somebody. And the thing that we've seen the need for is just validation or verification technologies, privacy pen testing, if you will. Security teams do this all day long, right? Red teaming exercises. Can you hack your own system? So on and so forth to ensure that your infrastructure is buttoned up. Privacy folks haven't traditionally done that, but I think a lot of the CIPA activity has forced that. So there's great technology to just verify that your opt-outs work. Hey, this particular system is collecting data after I opted out and shouldn't. You should fix it. So I'm a big proponent of that. There are a few vendors that provide that sort of technology. I know companies will pay consulting firms to go and do that as a one-off. I think the challenge with that is, first, it costs a ton of money to do one time, and it's only done one time. And the nature of a digital product is that it's changing constantly. Your marketing team has done 30 different new things without your knowledge in the last week alone. So you need something that's relatively consistent. So I think that's the first thing is companies can avail themselves of privacy pen testing technology. The second thing is I do think that there's an opportunity for data teams and privacy teams, or privacy plus marketing, the data practitioners in the organization, to just be a little bit closer. I think that the folks who run the privacy program are to be lauded for taking on such a monumental task. It's just so hard to do this. And it's not necessarily the actual expertise of a legal practitioner to understand how a business wields, operationalizes data, and how they could pick technology to effectuate the obligations as stated in these laws. And I don't think it's a reasonable expectation that they should be able to do all that all themselves. So I do think that there's an organizational change dimension of this conversation that needs to happen, and we're slowly seeing, this is happening, right? CISOs are showing up to the party a little bit more. Our sophisticated customers have really, really smart technical folks supporting them. So the organizational change definitely needs to happen so that the privacy pros get a little bit of help to evaluate technology and tools that can be used to effectuate these obligations.
Well, Max, I think those are really important insights. And I feel like we could probably go on for another hour, but maybe for the benefit of all of us, we'll probably cut it there. I really appreciate your sharing your time and your expertise, and for your creation of really great and valuable solutions for many of our joint clients together, and for kind of the larger community in the space.
Well, thank you for having me on. It's been a lot of fun, and hopefully we'll do it again soon.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.